Muslim-majority states are, at present, following alien legal systems that are based on the two major legal traditions found in the world today. The following of alien legal systems has hindered the political, economic, and legal development of these countries. These countries remain backward, although Muslims occupy the most fertile lands and the most strategically located countries that are rich in minerals and other natural resources. In order to make progress, Muslim countries must prepare to adopt a law that is compatible with their history and is culturally suited to their needs. The Cornell Legal Information Institute says, "A legal system is a procedure or process for interpreting and enforcing the law." There are hundreds of legal systems in the world, but despite this great variety, it is important to begin by emphasizing one great division, that between religious and secular legal systems. Each side of this split holds quite different views as to law, in its source, scope, sanctions, and function. The most important classification, therefore, is of religious and secular legal systems. In religious systems, the only legal system that exists in reality is the Islamic legal system. The Jewish, Christian, Hindu, and Buddhist systems never existed in history as proper legal systems, nor do they exist today. The Christian canon law was not religious in reality. It was secular and was part of the civil law. It is only the Islamic legal system that has been practiced in history and the system that has survived. Not only has the Islamic system been practiced in the past, but it has also survived till the present times, and it also has a very bright future. Before we begin comparing the Islamic legal system with the common law and the civil law, it is important to highlight and compare certain important features of the early legal system of the Roman Republic with those in the new Islamic legal system. The first feature is the creation of the jurist as a distinct class. The second is the absence of recorded judgments and precedents. And the third is borrowing by the Islamic system and subsequent borrowing by common law and possibly civil law. These features will be examined and compared in this video, which is part 1, after which we will be ready for a comparison of the systems in part 2 of the video. Apple and Daling maintain that the civil law system originated in the Roman Republic. By the year 27 BC, a body of legal experts, or jurists, had gained prominence within the legal system, separate and apart from the courts of law. These jurists were men from the upper classes of Roman society, interested in the law and in providing counsel about the law as a public service. They provided advice to parties and to the lay judiciary, as well as to legal magistrates who instructed the lay judges on issues, procedures, and remedies available in particular cases. The jurists created a role for themselves by the year 250 AD. The main reason was that the magistrates and judiciary, the praetors and the judices were non-professional, and they came to be totally dependent on the jurists. The jurists responded to specific questions of law in a document known as a responsa. Ultimately, it was the responsa that enabled the jurists to develop a comprehensive jurisprudence, as well as through the interpretation of textual material, such as from the 12 Tables, an early statement of existing law, circa 450 BC, or the Edict. The role of jurists came to be preeminent in classical Rome, to such an extent that it could be validly argued that the Roman private law system was entirely dependent on them. Further, another practice that helped elevate the role of jurists was Caesar Augustus's practice of patenting jurists, by which certain jurists were singled out for recognition. Islamic law was born less than a century after the death of Justinian, who is well known for the Code Justinian. The source for Islamic law was 600 or more verses of the Quran that had legal content. These legal verses were supported by about 2,000 or more traditions. Reports about the sayings, acts, and approvals of the Prophet, peace be upon him, that had a legal content. The companions of the Prophet, God be pleased with them, especially those in positions of authority and those who had acquired a deep understanding of these legal texts, issued rulings for people seeking a resolution of their disputes or guidance for their personal acts and acts of ritual devotion. The followers of the companions and their followers devoted themselves to the systematic study of their legal texts and rulings. These jurists started organizing themselves into schools that preferred particular systems of interpretation. The first to appear on the legal scene was the Hanafi school. This was approximately a little more than 1 century after the departure of the Prophet, peace be upon him, from this world. The appearance of this school coincided with the maturity of the Islamic legal system. This was also the time when the political power passed on from the Umayyads to the Abbasids. The year, according to Joseph Schacht, was 750 Common Era, or 132 after Hijrah. The Hanafi school contributed in a major way to the development of the law, with Imam Muhammad al-Shaybani recording the doctrines of the school in copious works that dominated the Islamic legal scene for the next 13 or more centuries and are still the authoritative texts of the school. The growth of the jurists in Islamic law was almost similar to that in Roman law. There were, however, major differences. The first was that the judge, or qadi, was not unprofessional or untrained. The qadi was usually a trained jurist in his own right. The Muslim jurists not only issued fatwa like the responsa, they systematically and in an organized way created their legal manuals, which serve us even till the present age. Further, there was no system of patenting of jurists in Islamic law. Instead, many of the jurists were appointed as qadis. Notable among such appointments, in the early times, were those of Abu Yusuf and Muhammad al-Shaybani, the disciples of Abu Hanifa. Besides the jurists, there was another similarity that we should notice. Apple and Daling maintained that judicial decisions were never accorded any importance in the Roman legal system. Thus, Gaius did not recognize judicial decisions as a basis of Roman law in the preamble to his Institutes. Written in the 2nd century AD in the 6th century, the Emperor Justinian drove the final nail in the coffin of Roman judicial precedent and judicial precedent in later systems as well. In the encyclopedic work commissioned by him, the Corpus Juris Civilis, with the dictum, "Decisions should be rendered in accordance, not with examples, but with the law." The rejection of precedent elevated the importance of the jurists and their written opinions. The role of jurists came to be preeminent in classical Rome, to such an extent that it could be validly argued that the Roman private law system was entirely dependent on them. The same thing happened in Islamic law. The general rule was that analogies were not to be constructed upon analogies. Instead, the jurist or the judge should have recourse to the texts of the Quran and the Sunnah for further analogy. Accordingly, records of judicial opinions are almost non-existent. In later Ottoman times, the judges did record their opinions, but they did not serve as a basis of precedence. It is important to note that during the period when Islamic law reached maturity and was then recorded by the Hanafi school in the authoritative texts, Islam had conquered and annexed most of the civilized world, including the Byzantine and Persian empires. It is well known that texts were translated from Greek and Latin as well as other languages. Islam borrowed much from different civilizations and cultures. Islamic law did not lag behind. Many institutions and ideas were acquired from different legal systems. One thing was certain, however, that all ideas, concepts, and institutions borrowed were passed through the sieve of the sources of Islamic law. All incompatible things were rejected, and those that were compatible were adopted. In fact, every culture and system borrows from other systems, but the crucial difference is that most of them do not have a core body of principles emerging from sacred texts against which these borrowed ideas are tested. Writers like Makdisi have tried to show the influence of Islamic law on the development of English common law. Makdisi goes into great detail to show what legal institutions may have been borrowed by English common law from Islamic law. He then proceeds to show with the same detail how the Normans transplanted Islamic law in England from Sicily, where the Muslims had ruled for 200 years before the Norman conquest. He says, England and Sicily were the only two states in the 12th century that had Norman kings, and the Normans had a strong sense of nationality that can be seen in their common institutions. In particular, the reigns of King Roger II from 1130 to 1154 in Sicily and of King Henry II from 1154 to 1189 in England shared many features. Historians have often remarked on the similarity between these two states in the treasuries that administered taxation and finance, the high courts that administered justice, and the chanceries that directed and coordinated the work of the other departments. Here, we are not interested in details, but 2 points need to be addressed. The first is that when the whole of Europe, under the influence of the Corpus Juris Civilis, adopted systems of codification, why did England opt for a system of unwritten laws? The reason seems to be obvious. Islamic law did not adopt codified laws, and this appears to be the major reason for the absence of codification in England. The second point is that Europe, following the Roman ideas about earlier judgments, rejected the system of precedents, but England, deviating from this, devised and followed a system of precedents. A possible reason could be that there were no jurists, nor did the tradition of jurists develop there. Consequently, the judges replaced the jurists as the authority for determining the law. A question that we may raise here is, if the law of England had come under the influence of Islamic law, was there no influence on the civil law of Europe? It is true that Islamic law had been influenced by the earlier law of the Roman Empire, but by the 11th century, it was the most developed law on the planet. Further, there was greater interaction during this time between Europe and the Islamic world, both through wars and trade. An interesting point is that Justinian's code had become non-existent between the 7th and the 13th centuries. It was magically revived from fragments. It is stated in Wikipedia, in the West, Justinian's codex was largely lost, or in many places never present, due to the limited western extent of the Byzantine territories. The Latin version known today was painstakingly restored over many centuries. The only known manuscript is now only fragments. The introduction to the translation of the Codex of Justinian says, this whole process lasted about 100 years, starting perhaps in the second quarter of the 11th century and finishing in the early 12th century, when a reintegrated codex came into existence. The codex that emerged from this was not quite Justinian's original. The reason why we mention these details is that there are too many similarities between the structure of the civil law and Islamic law. Can all this be a coincidence? We think not. There appears to be some influence on the form of text created. A code on Jewish law written by the famous Maimonides in Hebrew appears to be quite similar in form to the Hidayah. In Europe, the glossators appear to have been influenced by the writers of hashiyas or glosses on the margins of original major texts. Islamic law continued to be very influential right up to the 16th century. The two major centers for the growth of this law were Ottoman Turkey and the Indian subcontinent. After this, the Muslim states started becoming weaker, and the rise of Western civilization began. This was followed by colonization, which resulted in the arrest of the growth of Islamic law. In fact, in many colonized states, the law was replaced by civil law or common law, as the case may be, while Turkey gradually moved to alien laws voluntarily. Laws of marriage and divorce or personal laws were still applied in these countries. This has led to mixed systems of law. After the Second World War, Muslim states gained independence, but they have found it difficult to understand how Islamic law was implemented in earlier times.